The application, my Lord, seeks orders that are conservatory in nature against the listed respondents. My Lord, to begin with, I want to note that when this matter was filed, the court did not issue interim orders. But 2 days later, the first respondent and the second respondent summoned the second, fourth, and sixth petitioners.
2 days later, there?
My Lord, sorry?
2 days later, which party?
The first and second respondents summoned the second, fourth, and sixth petitioners on a Friday with indications that they were going to detain them and charge them in court on Monday. On that date, my Lord, underwriting behind the scenes, they were compelling them to resign as directors of the seventh petitioner. My Lord, that's when this court was moved and it did issue a conservatory order. The one that you have subsequently extended on 2 occasions. So, my Lord, today we are dealing with the application, which is for conservatory orders, as I mentioned, and the considerations for grant of this relief, my Lord, has been set out in several cases. The most important one being the Supreme Court of Kenya decision in Peter Munya versus Githinji and 2 others. That is application number 5 of 2014. And my Lord, in that case, the Supreme Court established the rule that conservatory orders ought to be granted on the inherent merit of the case, bearing in mind public interest, constitutional values, proportionate magnitude. My Lord, I have this in my paragraph 22. The court will look at it of my submissions. And my Lord, in a subsequent decision of this court in Tayabali and another versus AG, the court expounded what the Supreme Court meant on the first criteria, and it said that it's a case that is not frivolous, one that has a prima facie, that is prima facie. And my Lord, more importantly, the court explained that at this stage, we are not imploring the court to delve into the merits of the substantive petition, but just to make an assessment of whether the pleadings disclose a case that is not frivolous. So, my Lord, on this first limb, we will be urging the court to peruse the petition. And if you do this, my Lord, you'll encounter more than one ground upon which you will find that this petition is not frivolous. And I'll demonstrate just in a minute. My Lord, one of the issues that this petition intends to ventilate is whether the President can decree that the Director of Public Prosecutions should arrest somebody and charge him, and he actually goes ahead and does that. My Lord, when you look at the annexures, annexure number 1 to this petition, you will see that the tribulations of the petitioners started when the head of state announced in a political rally that the petitioners, whom he profiled as charlatans, fraudsters, and conmen, will be removed from the directorship of the hospital and charged in court. And on the same day, they were actually arraigned and charged in court. And we will be interrogating whether Article 157 allows the president to exercise such a role, and whether the DPP can free himself from such an acclaim. So that makes this petition to be having overwhelming chances of success on that ground only. The second issue, my Lord, is that at the time of the arrest of the petitioners, the High Court in Kibera Miscellaneous Application number E062 of 2025 had actually granted them anticipatory bail. And I'm speaking to the 3rd, 6th, and 5th petitioners. My Lord, they had anticipatory bail, but they were being arrested. And this court will, at the hearing of the petition, need to interrogate whether the Director of Public Prosecutions and the Director of Criminal Investigations can actually arrest a citizen who has an anticipatory bail. My Lord, third is that at the time of the proceedings that are impugned through this application, because we are seeking to stay lower court proceedings also, my Lord, your brother, Honorable Justice Sifuna, had issued an order in High Court Civil Case number 173 of 2025.
In High Court?
Civil Case number 173 of 2025. Restraining.
Civil case number?
Number E173 of 2025. Restraining the the second and third respondents from summoning, questioning, or even interrogating the petitioners who are witnesses in that matter. My Lord, all these things were considered to be of no value to investigative agencies who were determined to change directorship of the seventh respondent using the machinery of criminal justice. And my Lord, it is for these reasons, among many others that we shall argue at the hearing of the petition, that the petitioners have established a case. I would describe it as one of the clearest of the cases when this High Court should intervene, my Lord, with a relief. My Lord, the next limb will be the question of prejudice, which I'll argue very briefly because my colleagues will weigh in much more on that. My Lord, after this court issued the order that it did, there has been a relative calm and tranquility at this institution. It was at a time when the Kenya Revenue Authority, the Asset Recovery Agency, and the other agencies that had been co-opted into the consortium of the executive to deal with the 7th petitioner's conditions, they were on their case. But after these orders were issued, there has been relative calm and tranquility at that facility. That itself is evidence of how the intervention of this court has gone a long way to bring in stability. And my lord, we must take note that this is a health facility that handles many Kenyans, that discharges a critical service to Kenyans. And the fact that the activities of the respondents that are in bad faith can cause substantial disruptions into the activities of that institution, my lord, itself is a prejudice that will warrant an intervention. My lord, if the orders that are sought are not granted, the respondents will not stop at pursuing change to directorship through coercion, through threats of use of the criminal justice system. And my lord, if this petition succeeds, at the end of the day, when you say the president had no role to play, the head of public service had no role to play, and the ODPP ought not to have been co-opted into this venture, my lord, the damage will already have occurred in a very material way. We have noted, my lord, in our petition and application that even while they are using criminal justice system to coerce the petitioners to resign from the directorship, the investigations are continuing and they are very indiscriminate. One of the documents we have annexed is a letter where they are commencing investigations while already prosecuting people. And my lord, this type of interventions, on the face of it, are highly contra statute. My lord, on the last limb, the Supreme Court required that we consider public interest. And there's no doubt that the state is deploying significant resources to achieve this objective. Very significant ones. My lord, the 7th petitioner was arrested, not the 7th, but the 5th petitioner, for example, was arrested in Kisii with a contingent of more than 12 police officers, then dragged all the way to Nairobi. And my lord, those type of resources are public resources that they're using. And that's a consideration that the state must not be allowed to deploy public resources in furtherance of actions that are prima facie unlawful, like we have described here. So that, my lord, it is not in the public interest to spend large sums of money to disrupt the activities of a hospital, my lord, to subject individuals with anticipatory bail to criminal processes when the intention of those criminal processes is to secure something different other than honest enforcement of criminal law. And my lord, as I finish, it is not enough for the state agencies to just claim that we are doing our work, that all we are doing is our work, because that type of defense can be made even in respect of the most egregious act of the state. The government can just shoot people out here and the police can claim that we are doing our work. So the fact that the ODPP has powers to prosecute, or that the Asset Recovery Agency has powers to investigate some forms of crime does not warrant them to do that which is wrong. There's no blanket power that has been donated to them. They must act in good faith, and they must act only in circumstances when they are pursuing what is good for the general public, but not pursuing an interest of certain few individuals. And on this note, my lord, I will note that half of the petition's grievances are directed at the interventions of the head of public service. And it is noteworthy that the head of public service has not done an affidavit to refute any of the allegations that have been mounted against him. Even the fourth respondent who acts for him in these proceedings has stayed clear from responding to any of the allegations against him and the generalities. My lord, also most importantly is that while the first respondent, the ODPP, is the one that has shot the gun with that inflicted the most, he has not done an affidavit in this matter to refute how he made his decisions to prosecute. Instead, a police officer is the one who is swearing an affidavit to say that the director of public prosecutions made his decisions independently after considering certain factors. My lord, this all is evidence of public officers who are aware that their power is being abused, but they are not prepared to own up to it. And we are urging, my lord, that on the strength of this submission and on what has been put down that I have not covered because of the time we have, that you allow the application and grant the orders that are sought. My lord, we will then come back and argue the petition and bring out all the issues that we want to bring out. But this is an illegality, my lord, that you have the power to bring to an end. And that will be it from me.
Okay, Mr.
Good morning,
Thank you,
Lordship.
Dr. Okubasu.